Association, and what we're about, we represent approximately 700 prosecutors in the state. So there's a lot of responsibility there, and our main goal is to keep the organization going for training, to work with the legislators and things of that nature, so that we can improve the justice system with training the best prosecutors, so that when we have a trial and the witnesses are called to trial and they later die, we don't have to worry about having to retry that case. I mean, I'll give you a prime example. Wilbert Rito is walking the streets right now, and he killed, supposedly, 2 bank tellers begging for their lives years ago. He went to the pen. He was the editor of the Angle Light, if I remember correctly, and now he's on a speaking tour around the state. They reversed the convictions. I don't think it was because of prosecutorial error. I can't remember that, why they did that. When they retried him, the witnesses were dead, and the jury found him not guilty. So, I mean, for legal purposes, he's not guilty. We don't want to have to worry about those sorts of things because of lack of training, and that's what we're about. So tomorrow at 1:30 at the Shreveport Bar Center, 625 Texas Street. It's just west of the Robinson Theater. So look forward to seeing you there. The media forum will be at 1:30, and then I'll be sworn in shortly after 2 o'clock. So come by. I'd love to see you, but I know everybody's busy and have things to do. You can be there. I'd love to see you.
What do you consider the main issues right now for the district attorneys around the state?
It's hard to say, Marion. Right now, the movement of cases, there's a big push to keep the unsentenced prisoner level as low as we can. For example, in Caddo, that jail was built for 1,170 prisoners. Back 4, 5, 6 years ago, it had 1,400 out there. The more unsentenced prisoners there are, the heavier the burden, the tax burden on the local taxpayers. Once an inmate becomes a DOC, Department of Corrections, state prisoner, the state helps bear that burden, and not just the local taxpayer. So we're trying to move the cases through. The other thing is to, obviously, we want persons, if they're innocent or if they're entitled to some probated sentence, that they get out of jail, get back to work, so they can be productive citizens. They may be under some supervision, such as probation. So that's a big part of it, to keep the system moving and moving smoothly.
Is there anything on this change to reduce the incarceration of the minor drug offenders? I know some of the marijuana charges are being taken out.
There've been some comments, Marion, principally by criminal defense lawyers, that they want to get the second offense drug offenders out of Angola and out of Department of Corrections. But the facts are minor drug offenders don't go to jail. Sometimes even a first-time felon is not going to go to jail. But, possession of marijuana right now, first offense is a misdemeanor. And we can process those misdemeanors much more quickly, obviously, than we can felons. So they're dealt with as misdemeanors. Often when they come back and it's been 2 or 3 years since they've had a prior possession of marijuana, we'll just go ahead and let them plead guilty on a misdemeanor or try a misdemeanor. But we do have some instances where we want to have that right to prosecute them as a felon. If we have drug gang members, for example, or if we think they're really dealing and they only get caught with what they have left and haven't sold yet, and they've got a bag full of money, we want that opportunity to put a felony on them. So if they want to join our frequent flyer program for habitual offender purposes, we'll help them get started.
Is that habitual offender law still pretty much intact? As they passed the Act 401 last year that let some folks get out, non-violent offenders get out?
There were some changes last year.
I think this year Gina was pushing for it, correct?
He was pushing for it, and others were as well.
But we still have the habitual offender statute.
Absolutely.
Or statutes on the book?
Right, absolutely. 15-529.1.
Yeah, and that's for non-violent, violent.
And it's a big tool because, 95% of our cases are plea bargains. Because the defense knows if they represent someone who has a prior felony, and we can put the habitual offender on them, that they serve their time flat, they don't get good time credit.
95%.
And you know what happened if it slipped to 90%? We'd be trying cases over there every day, all day into the night, and then the system would back up. So, and it's been that way. It was that way 10 years ago. It was that way 20 years ago. It was that way 30 years ago. You know, we moved through the system. We divert some cases and put them on a program so that they're monitored, drug screened, and things of that nature, and then many are on probation.
It seemed like sort of interesting change, and we did a piece last night, a guy who was sent out in '94, 3 drug convictions. And in '94, I think was the year we had the most homicides in the city's history, one of those years in there. That was part of the deal about let's put people away, get them off the streets, get tough, your gang activity was more. And now, some of the very same law and order folks seem to be now pushing for, let's get them off the books. Let's get them out of jail. It's costly.
It's costly.
It looks horrible. I mean, we got the highest incarceration rate in the
exactly
world.
right.
So it's kind of an interesting tension. Do you have any thoughts about where you kind of come down in that tension?
Absolutely. You know, one of our biggest jobs, as Marion, asked about jobs and what is our focus. We've got to keep the administration and the legislature informed that there's a balancing. There's a monetary cost on this side of keeping people in jail, and there's a human cost on this side. So, the fact that you hear about nonviolent offenses, well, they may be in for a nonviolent offense, but that does not mean they do not have a history of violence or coming from violence. The drug section, which is the busiest section of court we have, it was created because we couldn't get to the drug cases. I mean, if someone was on the docket for a jury trial behind a murder, rape, or robbery, then they knew that drug case wasn't going to be tried. And so they stayed in jail, finally had to plead down to something the defendant. The defense was really driving the train on that because they couldn't get them tried. But when we started the drug section, we moved those cases through from the distribution of drugs and possession with intent to distribute drugs and weapons and things of that nature.
Is the bench getting a little more latitude? I mean, I used to hear from judges, maybe even you at one point, saying our hands are tied. There's a lot of things, sentencing or some mandatory sentencing. Are they getting more leeway to say a guy with 4.4 ounce crack or coke, whatever the drug of the moment is, is a little different than a fellow who's out there maybe strong-arming folks and that sort of thing?
They have a great deal of latitude, but a lot of the latitude, Craig, is driven by the offense charged and convicted. For example, if I charge someone with possession with intent to distribute or distribution of drugs, there's a mandatory minimum. And then if he's charged as an habitual offender, because we think he's a really dangerous guy, that the community is endangered by this guy, then the judge's hands are tied with the habitual offender.